Hello friends, in the series on the income tax cases, today we will discuss a very important case on section 271 AA. The title of the case is Jyoti Paper UDYOG Limited versus Assistant Commissioner of Income Tax, and this case has been reported in 107 ITR Tribunal, short note 16, and the matter has been decided by Pune ITAT A bench, and the date of the judgment is 20th September 2023. This case is related to the assessment year 13-14, and in the present case, when the assessment proceedings were going on, the assessing officer observed that the assessee has made payments to the related parties under section 40A subsection 2 clause B. From the assessment year 13-14, the provisions of specified domestic transactions were introduced. That was section 92D, that was regarding maintenance and keeping of information and documents by certain persons, and section 92E talks about report of an accountant in case of international transaction and specified domestic transactions. Since the assessee has crossed the limit of 5 crores of payments to the related parties, so the provisions of section 92D and 92E were applicable to the assessee. The assessing officer during the assessment proceedings asked the assessee to furnish the report of chartered accountant under section 92E, but the assessee was not able to produce that report. The assessing officer initiated the proceedings for penalty under section 271 AA on the assessee that you have not obtained the report under section 92E, so why the penalty under section 271 AA should not be imposed on you. It was the plea of the assessee that this is the assessment year 13-14 from which the provisions of section 92E are applicable for the first time, and the assessee has referred the matter to the chartered accountant who was looking into day-to-day matters of the assessee, and they have not suggested the assessee that they should go for the 92E report of the chartered accountant, meaning thereby that the assessee can maximum do is that he can consult a professional, and if the professional does not come out with the thing that the assessee has to follow some provisions, at least the matter which has been referred to the professional, then in that case it was the viewpoint of the assessee that the penalty should not be imposed on me because I am able to demonstrate the reasonable cause which is there in section 273B. Section 273B talks about the reasonable cause, meaning thereby that if the assessee is able to demonstrate that there was some genuine cause due to which the assessee was prevented from following some provisions, then in that case the penalty should not be imposed on the assessee. But the learned assessing officer was not convinced with the grounds of the assessee, so he go ahead with the penalty. The penalty was confirmed by CIT appeal, so the assessee was before the ITAT. When the ITAT heard the matter, ITAT said that this is the perfect case when the assessee is able to demonstrate the reasonable cause on two grounds. First, this was the first year when the provisions were made applicable, and the second point was that the assessee has consulted his chartered accountant in day-to-day affair matters, and he has not told him that this provision is applicable to him because they have mentioned section 40A subsection 2 clause B related party transactions in the tax audit report. So at the same time it is much expected from the professional then they should make aware the assessee that they should obtain this report also. So in the present facts and circumstances, it is very clear that if the assessee takes some professional advice and in the first year of applicable provisions, the penalty should not be very strict. The department should be very slow in initiating and imposing penalties in those matters. So the ITAT deleted much deserved penalty in the present case. at the end of this video. Once again, I am repeating the name of the case. The name of the case is Jyoti Paper UDYOG Limited versus Assistant Commissioner of Income Tax, and this case has been reported in 107 ITR Tribunal, short note 16, Pune ITAT A bench, and the date of the judgment is 28th September 2023. Thank you, friends.